Welcome back to Ace Your RES exam. Today we're doing a real deep dive into something absolutely crucial for your exam success: Singapore landlord and tenant law.
Yep, definitely a big topic.
Think of this as I guess, your personal shortcut. We've sort of distilled the key info so you get what you need without, drowning in legal jargon.
Exactly. Our mission today is pretty clear. Unpack the core ideas, focus on what's most likely to pop up on the exam.
Right. We'll look at what a lease really is, the different flavors they come in, the terms you absolutely have to know, and what happens when things don't quite go to plan.
Sounds good. Let's get straight into it. Think of us as your guides through this, aiming to make it clear, concise, and stick in your head for exam day.
Okay, first big question then. What is a lease? It's not just a simple rental agreement, is it? The notes say it's an interest in land.
Yeah.
That sounds significant.
It really is. Unlike just a personal contract, a lease gives the tenant an actual legal interest in the property. It's a right that holds up against almost everyone, not just the landlord.
So it's more powerful than just permission to stay.
Much more. It means the tenant's rights are tied to the land itself for the duration of the lease. So, key point for the exam. Tenant rights aren't just personal, they attach to the property.
Okay, and this leads to that dual relationship thing: privity of contract and privity of estate.
Exactly. You've got the direct agreement, the contract between the landlord and tenant. That's privity of contract. Simple enough.
Right.
But then you have privity of estate, which exists because the tenant holds that legal interest in the landlord's land.
Okay, privity of estate. Why is that distinction important for us for the RES exam?
Because it's the privity of estate that makes certain promises, covenants, stick to the land itself. We call them covenants that touch and concern the land.
Touch and concern, like what?
Things directly related to the property, like, say, the landlord's promise to maintain the lifts, or the tenant's promise to only use it as a residence. These kinds of promises can bind future landlords or tenants who take over, precisely because of privity of estate.
Ah, okay,
Yeah.
so even if the landlord sells, the new owner might still have to maintain the lifts because of that original promise.
That's the idea, yeah. It's a crucial concept for understanding how lease obligations carry forward.
Got it. Okay, now leases aren't all the same. The notes list a few types. Let's start with the fixed-term lease. Sounds straightforward.
It is, pretty much. It's set for a definite period, clear start date, clear end date. Like buying a ticket for a specific movie showing, it ends when the time's up.
Unless there's a special clause.
Right, unless there's an express clause allowing early termination, like a diplomatic clause, which we'll touch on later. But otherwise, the duration is fixed. Certainty is key.
Okay. Fixed start, fixed end. Easy enough. What about periodic tenancies? They sound like they just keep going.
That's a good way to put it. They roll over based on a period, weekly, monthly, yearly. It renews automatically until one side gives proper notice to end it.
And it can just appear, even without a formal document.
That's a classic exam scenario. A tenant stays on after a fixed term, the landlord accepts rent boom. You might have an implied periodic tenancy. The actions create the legal situation.
Right. Actions speak louder than, well, missing paperwork sometimes. Okay, next. Tenancies at will. Sounds very casual.
It is. The tenant occupies with the landlord's consent, but there's usually no rent paid, or at least not on a regular basis establishing a period, and no fixed term. Either party can basically say, time's up, whenever they want.
Like letting a friend crash on your sofa indefinitely.
Sort of, yeah. Or maybe someone gets keys early before a sale completes, or stays on briefly after a lease ends without paying rent yet, and the landlord hasn't objected. It's quite informal.
Okay. Consent, but no real commitment. Then tenancies at sufferance. The notes practically yell, not a lease. Why the drama?
Because it really isn't one. This happens when a tenant was there legally under a lease, but the lease ended, and they're still there without the landlord's consent.
So they're overstaying their welcome. Big time.
Exactly. They're technically a trespasser. The landlord hasn't agreed to them staying. And under the Civil Law Act, the landlord might even be able to claim double the rent for the period they overstay without consent.
Double rent. Ouch. Okay, definitely not a situation you want to be in. Lastly, for types, tenancy by estoppel. What's that about?
This is a weird one, kind of a legal fix. Imagine someone pretends to be the landlord, leases out a property they don't own, and you sign the lease in good faith.
Oh.
Right. Later, the truth comes out. Estoppel can prevent the fake landlord from denying the lease is valid between them and the tenant because they represented themselves as having the right to grant it. It protects the tenant who relied on that representation. It also highlights why checking ownership is so vital for agents.
Good point. Due diligence always.
Always.
Okay, so those are the types. Now, what makes a lease legit? The non-negotiables. First up, exclusive possession.
This is fundamental. It means the tenant gets control. The right to keep everyone else out, including the landlord, unless the lease allows specific entry rights, like for inspections or repairs, usually with notice and at reasonable times.
So the tenant gets their own space, their own bubble?
Pretty much. Without it, it's probably just a license permission to use the space, not a full lease with all the associated rights.
Right. If the owner can come and go as they please, it's likely not exclusive possession. Okay, next essential. Intention to create a lease.
Seems obvious, but the law looks for evidence that both sides actually intended a formal landlord-tenant relationship. This can be explicit in writing or implied from how they act, handing over keys, accepting rent regularly.
Actions again. Okay. Then, certainty of duration. We touched on this with the types, right?
We did. Fixed terms need clear start and end dates. Periodic tenancies need a definite period, week, month, year, even if the total duration isn't fixed from the start. The recurring period must be certain.
Got it. Now, the big one for exams must be in writing sometimes. When is a verbal agreement okay, and when do you need the lawyers?
Okay, general rule. Shorter leases, especially residential ones, can be verbal or written. But T, and this is the key bit from the Conveyancing and Law of Property Act, Section 53, any lease for a term exceeding 7 years must be made by deed, and that deed must be in English.
7 years. That's the magic number. Over 7 years needs a formal deed. Under 7, more flexible.
Exactly. Remember that 7-year threshold.
Will do. Last essential. Reversionary interest. This is the landlord side.
Correct. It just means the landlord keeps the ultimate ownership. The property reverts back to them when the lease ends. They own the property. The tenant just has the right to possess it for a defined time.
Landlord owns the cake. Tenant gets to eat a slice for a while.
Yeah.
Okay, so those are the essentials. But leases have loads of other terms. Beyond rent, what are the usual suspects?
Right. The notes break these down well. First, the premises needs to clearly identify who's who, landlord, tenant, and exactly what property is being leased, usually with a legal address. Clarity prevents disputes.
Makes sense. Then the habendum. Fancy name.
Yeah. It just means the part that states the lease term, how long it runs for, and the start date, the when and how long.
Got it. And redendum. Sounds like money.
Got it. Redendum covers the rent, how much, when it's due, how to pay. It also includes things like the security deposit, any service charges, maybe even rent review clauses for longer leases. Basically, the financial bits.
Rent, deposit, charges. Okay. And then covenants. These are the promises, right? Express and implied.
Precisely. Covenants are the obligations and rights of both parties. Express ones are written down explicitly in the lease. Implied ones are imposed by law, even if they're not mentioned in the agreement.
Okay, the written rules and the unwritten ones the law assumes. Let's pluck the implied ones for a second. What if people want to pass the lease on? Assignment, subletting, novation, what's the difference?
Big differences. Important for the exam. Assignment is when the entire remaining interest of the tenant is transferred to someone new. The original tenant is out. The new tenant, the assignee, steps directly into their shoes.
A complete handover.
Yes, and it creates that privity of estate between the landlord and the new assignee. Remember, leases over 7 years need assignment by deed too. This usually needs the landlord's consent unless the lease says otherwise.
Okay, so what's subletting then?
Subletting or creating a sublease is different. The original tenant grants a new, shorter lease to a subtenant. The original tenant stays in the picture, they become the subtenant's landlord, but are still the tenant to the main landlord.
Ah, so there's a middleman.
Exactly. And crucially, there's no direct link, no privity between the original landlord and the subtenant. Again, usually needs landlord's consent based on the original lease terms.
Right. So assignment is replacement, subletting is adding a layer underneath. What about novation?
Novation is like wiping the slate clean. It's a three-way agreement. Landlord, original tenant, and new tenant. They all agree to end the old lease and create a brand new one between the landlord and the new tenant. The original tenant is completely released from all past and future obligations.
So a total restart. Got it. Okay, leases eventually end. How does that happen? There's renewing, but also determination. What's an option to renew?
That's a clause giving the tenant the right, if they meet certain conditions like giving notice on time and not having breached the lease, to extend the lease for another specified term. It's a contractual right they can choose to exercise.
A pre-agreed extension possibility.
Cool. What about the ways leases just end? Determination.
Several ways. The simplest is a fluxion of time. The fixed term just expires. Clock runs out.
Makes sense.
Then there's notice to quit. That's how you end periodic tenancies. Either side gives the required amount of notice.
Standard procedure for rolling leases. What's surrender? That's when the tenant gives up the lease early and the landlord agrees to take it back. It's a mutual agreement to terminate. Sometimes money changes hands as compensation.
A negotiated early exit.
Well,
Okay. Merger.
merger happens when the tenant's interest and the landlord's interest end up owned by the same person. Like, if the tenant buys the property from the landlord, the lease disappears because you can't be your own tenant.
The two roles combine. Gotcha. Frustration. Sounds dramatic.
It usually is. It's when some totally unforeseen event makes the lease impossible to perform, like the building burning down or the government taking over the land. It has to be something radical that fundamentally changes the situation.
An act of God, almost.
Okay.
Okay. Exercise of an express power. Like a break clause.
Exactly. The lease itself might contain a clause allowing termination under specific circumstances. The diplomatic clause is the classic example, letting an expat tenant end the lease early if they're posted out of Singapore, usually after a minimum period and with notice and proof.
A planned escape hatch. And lastly, forfeiture. Yeah.
Sounds forceful. It is the landlord's remedy. It's the landlord's right to end the lease early because the tenant has breached a serious condition or covenant, most commonly not paying rent, or another breach where the lease explicitly says the landlord can forfeit.
Okay, the landlord taking back possession due to the tenant's default. Right. Let's backtrack to those unspoken rules, the implied covenants. What does the law imply the landlord must do, even if it's not written?
Key one is quiet enjoyment. Doesn't mean silence. It means the tenant has the right to possess and use the property without substantial interference from the landlord or people acting for them. Peace and enjoyment of the premises.
So the landlord can't just show up constantly or cut off utilities without reason.
Exactly. Then there's non-derogation from grant. Fancy way of saying the landlord can't do something that makes the property unfit for the purpose it was leased for.
Like leasing you shop space, then blocking the entrance.
Pretty much. Can't give with one hand and take away with the other. Another one is fitness for habitation, but be careful here. In Singapore, this generally only applies to furnished residential properties and only at the start of the lease. The place must be reasonably livable then.
Only furnished. Only at the start. That's a key distinction.
Very key. It doesn't usually cover later defects or unfurnished places, and it's about serious issues, not just minor inconveniences. Landlords are also impliedly responsible for paying property tax, insuring the building, and handling external and structural repairs.
Okay, the big stuff and the basics of ownership costs. Now, what about the tenant's implied duties?
Number one, to pay rent. Obvious but fundamental. Pay it on time as agreed.
The core bargain.
Then to repair, but qualified, in a tenant-like manner. This means doing the small jobs a reasonable tenant would do, changing fuses, unblocking sinks, keeping the place reasonably clean, not major structural work.
Basic housekeeping and minor fixes. Got it. What's not to commit waste?
Waste means damaging the property or letting it deteriorate beyond normal wear and tear. Could be deliberate damage, voluntary waste, neglect leading to damage, permissive waste, or even unauthorized alterations that decrease value. Fair wear and tear from normal use is expected and okay.
Don't trash the place, basically. And the last one, permit to view premises.
Right. The tenant generally has to allow the landlord or their agent reasonable access with notice and at reasonable times for things like inspections or showing the property to potential buyers or future tenants near the end of the lease.
Can't unreasonably block access. Okay. Now, beyond implied duties, let's hit some common express terms, things actually written in. Security deposit clause.
Standard practice. Landlord takes a deposit, usually 1 to 3 months rent, to cover potential damage or unpaid rent. It should be returned minus valid deductions after the lease ends. It's the landlord's protection.
Makes sense. Provide some security.
Then the diplomatic clause, again, we mentioned it as an express power, allows early termination for expats leaving Singapore under specific conditions, very common in leases over a year.
That specific escape clause. What about the minor repair clause?
This tries to clarify who pays for small repairs due to wear and tear. Often the tenant bears the cost up to a certain amount per item, say $150 or $200. Anything above that or structural issues typically falls to the landlord, unless the tenant caused the damage.
Sets a threshold for who calls the handyman. Okay. Not to sublet clause.
Very common. Landlords often want control over who occupies their property, So many leases outright forbid subletting or require explicit written consent, which the landlord might refuse.
Landlords want final say on occupants. Makes sense. Proper usage of premises.
Restricts how the tenant can use the property as the AG for residential purposes only. Prevents a tenant from, say, running a noisy business out of a condo unit meant for living.
Keeps the use aligned with the property type. And finally, observance of law, bylaws, rules, and regulations.
A bit of a catch-all. Requires the tenant to follow all relevant laws, government rules, and any building-specific regulations like condo house rules.
Follow the rules, basically. Okay, last major section. Things go wrong. What can a landlord do? Remedies. First is distress. Sounds painful.
It's a legal process, not physical. If rent is unpaid, up to 12 months' worth, the landlord can apply to court for a writ of distress. This allows a court official, the sheriff, to seize the tenant's movable goods on the premises and sell them to recover the owed rent and costs.
Wow. They can actually take your stuff.
Yes, but only movable goods on the property, and there's a formal process with notice. Importantly, distress doesn't automatically end the lease. It's purely a debt recovery tool.
Gets the money, but the tenant might still be there.
Yeah.
What about forfeiture as a remedy? We know it ends the lease. How does the landlord use it?
Right, it's the landlord's nuclear option, taking back the property. For non-payment of rent, the lease often allows re-entry after a certain period, like 14 or 21 days overdue, sometimes without even needing a formal demand first.
So rent is special. What about other breaches, like unauthorized subletting?
For breaches other than rent, the landlord usually must follow Section 18 of the CLPA. They have to serve a formal notice on the tenant that 1. Specifies the breach, 2. Asks the tenant to fix it, if possible, and 3. Requests compensation. Only if the tenant fails to comply within a reasonable time can the landlord then proceed to forfeit the lease, usually by getting a court order for possession.
So a warning shot and a chance to fix things, usually. Unless it's rent.
Generally, yes. The law provides tenants some protection against immediate forfeiture for non-rent breaches.
Okay. And the last remedy mentioned is equitable setoff, or just suing for rent.
Right. Well, fundamentally, rent owed is a debt. So the landlord always has the option to simply sue the tenant in court to recover the unpaid rent, just like any other debt collection process.
Just a straightforward lawsuit for the money owed.
Exactly.
All right. That's a pretty comprehensive run-through of landlord and tenant law for the RES exam. We've gone from the nature of a lease right through to remedies.
Yeah, we covered a lot of ground. Hopefully breaking it down like this helps solidify those key concepts, the lease types, the essentials, the covenants, how leases end, and what happens when agreements are broken.
Definitely. Remember those core ideas, folks? Especially the distinctions like assignment versus subletting, the 7-year rule for deeds, and the landlord's and tenant's implied duties. Nailing these will really boost your confidence.
Absolutely. Understanding the why behind the rules often helps them stick better than just memorizing facts. Think about how these apply practically.
Couldn't agree more. We really hope this deep dive helps you prepare and feel more confident going into the exam room.
So from both of us, the very best of luck with your upcoming RES exam.
Yeah, go ace it.